Hi there. This is Chapter 2, Role of the Courts, lecture video. You should have your PowerPoint open and your textbook next to you. Let's start with slide 6. Checks and balances. The federal Constitution establishes 3 branches of government. Each branch, the 3 are the executive, legislative, and judicial, operates as a check and balance on the power of the other branches. In addition, federal and state governments operate as a balance of power in the federal system of government. Let's look at page 27 of your textbook. Under checks and balances, federal judges, the judicial branch, are nominated by the President of the United States, the executive branch, but they must be confirmed by the Senate, the legislative branch. New federal laws must be approved by Congress and signed by the President, but the judicial branch can rule that they are unconstitutional. Most states have similar checks within their system. So you see how that checks and balance work with laws. Let's look at slide 7, independent judiciary. The courts monitor and restrain the executive and legislative branch, or they're supposed to. Judges are appointed for life in the federal system, and they can only be removed or impeached for a major crime. State judges are selected by a variety of means. They are elected, appointed and then confirmed by an election. Page 28 of your textbook. Independent judiciary. An independent judiciary means that although politicians appoint judges, they do not have the authority to remove them from the bench because of unpopular decisions. Judges do not leave office when the party that appointed them loses power. In other words, if you had the Republicans in power or a Republican president that appointed a judge, and then you had a Democratic president in office, that doesn't mean a judge would automatically be removed from office just because of different points of view in a political party. Federal judges are nominated by the President of the United States and confirmed by the Senate, and a simple majority vote is required. Once confirmed, the federal judge holds office during good behavior, which really means until they retire, most of the time. The House of Representatives can impeach a federal judge for a conviction of treason, bribery, or other high crimes and misdemeanors. Judges have been impeached after being convicted of bribery. Only 8 federal judges have been removed from office by impeachment. State judges do not serve for life. In some states, the initial appointment is by the governor or judicial council, but after assuming office, the judges face election periodically. Other states, a person can become a judge only by winning an election. In some states, they use a combination of both systems. On page 29, you'll see a flow chart, a typical court organizational chart, where you'll see the Supreme Court is at the top, followed by the Court of Appeals or district courts, followed by the various county or trial courts. Slide 9, the court structure, federal. The United States Supreme Court is the highest court and hears only appellate cases. The U.S. Courts of Appeals is also an appellate court, and there's 12 circuits or regions, and that's sometimes called circuit court. And the U.S. District Court, it's a trial court with 94 district courts. Slide 11, the state court structure. You have the state Supreme Court as the highest state appellate court. The state courts of appeals, you have the state superior court, and that's a trial court that hears felony cases. You have the state district court. It's a trial court that hears misdemeanor cases, but not all states have 2 separate misdemeanor and felony courts. Some combine them. And you have small claims or magistrate court, a court that hears minor cases and including traffic cases. Slide 12, statute of limitations. Under state law, the government has a limited time to bring charges against an individual for a crime. This varies from state to state, and some states have no statute of limitations. No state has a statute of limitations for murder. And also the statute of limitations vary from crime to crime also. Each crime, different crimes might have different statute of limitations. Look at page 30 of your textbook. The authority of the courts is also limited by statute of limitation enacted by legislator. The basic concept is that it is unfair to leave criminal charges hanging over someone indefinitely. Specific laws establish expiration dates for charges. If charges are filed after the statute of limitation is run out, the defense has the right to have the charges dismissed, but murder usually does not have a limitation. Usually you'll have, for a misdemeanor, 1 year from the day the crime was committed, and felonies usually 3 years, possibly longer. In fraud cases, it has to do with when the fraudulent was discovered, when the fraudulent activity was discovered. Usually that's when the starting time is, not when the crime actually occurred, because sometimes it's difficult for someone to discover that fraud has occurred, such as identity theft. Many states suspend the statute of limitations if a suspect flees the jurisdiction to avoid prosecution, and that's called statute of limitation is told. So that's a different caveat. Under function of various levels of courts on page 30, each level of court serves a distinct purpose. There is no consensus nationwide on what names apply to each level. But for the purpose of the discussion in this book, it's going to be assumed that there are 3 triers of court. The low level, for the rest of the textbook, the low level will be called the trial court. The first level appellate court will be called the Court of Appeals, and the highest court would be called the Supreme Court throughout the rest of the textbook. But it can have different names from state to state. State trial courts process the case from the time the charges are filed through sentencing, and the workload involves the pre-trial phase. Only a small percentage actually goes to trial, though. The appellate court considers transcripts generated by the trial court, and no witnesses are called, no new evidence is introduced. Just for some clarification, that wasn't in the PowerPoint. Let's look at slide 13. Functions of the state court. State trial courts handle most cases, even those that don't go to formal trial, and they determine guilt or innocence. And there are admission of evidence is covered, which will be discussed greatly later in the textbook. State Court of Appeals reviews trial courts, and the state Supreme Court is the final review of state trial and appellate cases. We already talked about state trial courts on the bottom of page 30. Let's look at page 31 of your textbook, the first main paragraph. One of the most important roles of the trial court is to assure that due process rights are met. The judge makes sure that the defendant is given proper notice of the charges and that the right to counsel is satisfied. If there's a plea bargain, the trial court judge evaluates the fairness of the deal and conducts a colloquy to determine constitutionality and that the defendant hasn't been coerced and that they understand the consequences of the plea. Let's look at state courts of appeals on page 31. They review what occurred in the trial court. One exception is for death penalty cases. That's usually forwarded straight to the state Supreme Court. And then let's go to the bottom of page 31. State Supreme Court usually has one panel of justices who hear cases as a whole. And usually there's only a small number of cases that are considered. And the state constitution and legislation establish the state Supreme Court jurisdiction. It may be mandated to hear certain types of cases, such as death penalty verdicts, or a disbarment of an attorney, but it has the authority to rule that a law violates the state constitution. And it also hears cases referred to as discretionary appeals that are selected by justices. So additional info than what the PowerPoint has. Slide 14, function of federal courts. Federal district courts hear cases involving federal crimes and civil cases if it's warranted. And the federal courts of appeals oversee trial courts. The U.S. Supreme Court rules on constitutionality of laws. Marbury v. Madison is an example, and oversees court system. Page 32 of your textbook. Federal trial courts, they hear cases involving violation of federal statutes. A U.S. district court also has diversity jurisdiction that enables them to hear civil suits between litigants who reside in different states. So that's a different twist to what they also do. Federal courts of appeals, an appeal from the U.S. District Court goes to the Court of Appeals, and it's a panel of 3 judges. And then the U.S. Supreme Court, the U.S. Constitution does not explicitly give the courts the power to rule that laws are unconstitutional.